reforms. We think that there is need for reforms. The extremes that they went to by tying our hands for public safety is what our concerns are about, and the unfunded mandates that come with it. That being said, I'll turn it over to you.
And give us the necessary funding to ensure that we can have fair trials. Now, we also spoke about the statute when it comes to giving out witness statements. Who is opposed to that? But you have to give out the name and what's called contact information. Now, I think in the United States today, and I joke around, I'm not sure, but if you give me contact information about you and your name, I think in $100 in 2 hours, I'll find out where you live. Why are you getting contact information? To permit the defendant and or his attorney to speak to that person. And I think that's going to have a very, very chilling effect on witnesses or victims coming forward. If I watch something that's going on out in that hallway, I'm a witness. That means my name has to be given over, contact information. I think they can find me if they really want to find me. I don't think that's a good idea. We could change that. We could change that in a way and say, all right, we're not going to give you, we'll give you the statement, but we may not give you the name and contact information to the eve of trial, and only if we intend to produce that person to be a witness. So there are things that can be done, and we need to protect the witnesses, particularly when it comes to cases of domestic violence. You know, much of the work in the last 2 decades has been to protect the victim of domestic violence. Well, now you have to give out the name, you have to give out the name of the witness. We know that within 12 hours, the defendant has to be arraigned. That's the new statute. And very unlikely, in most cases, that they be detained. They can be held long enough to be arraigned before a magistrate and receive a protective order. But that's not the same as saying they're going to be off the streets for a while. They'll be back out again. That's something that should be needed to be looked into. Now, we also heard talk about if the defendant is there's the venue or scene of the crime, the defendant will have a right to apply to the county court, the judge, and get it in order. It's not going to be the same. It's going to take several weeks before you go back. So it's pretty much going to be cleared up, so we're not sure what the benefit is. But we can assume at the very least the defendant's attorney will be there. We're going to need police. I'm going to have to send an assistant district attorney and an investigator at the minimum to ensure that there's no violation of any order, all of which is going to cost money. And so I'll go back. Please go back to your legislature and say, we need to have all of this funded if you believe that this is the only way to go. So I just want to give you a different highlight. I want to say basically I support most of the reforms. The substance of would be, let's extend the period of time on open discovery. Let's come up with a method that the victim and the witness's identity is protected unless there's no other way to do it, and limit access to those individuals unless there are very controlled circumstances. The same standard should be used if it's going back to a person's house. Let's limit the access. Make it a burden on a defendant that the information that they seek to obtain cannot be obtained by any other way. If we give you pictures of the bedroom, if we give you all the dimensions, and we go this and that, come up with a real good reason why do you have to go back. So I do think that criminal justice is in need of reform, but these are not the way to do it. Let's mandate strong, speedy trial laws, make sure that anybody that is in jail gets a quick trial if they have to be in jail. So there are other means to do it. And please, if the legislature decides to do it this way, we have to have the necessary funds to protect the rights of the defendant and, again, the rights of the individuals, the victims, and the witnesses. And thank you for your time. Thank you.
We'll do that. We'll try to take a few questions, and then we'll see how it goes. How's that? All right? So, I know that I saw your hand come up before, right? You're even anxiously waiting, and then I'll get to you. Okay? Fair enough?
In participation of law enforcement authorities, that's number one. And number two, sticking to the question of bail for a moment, because that seems to be always mentioned as one of the biggest issues. Was there ever a study made where a person could not afford to pay the bail and yet was not convicted of the crime? Was ever a study made of how many people were affected by that situation?
So you asked two questions. So the first question, we've asked our state legislators, I'm talking about in Albany, not locally, to have input as sheriffs, as chiefs of police, and DA. We were shut out.
Why? Do they tell you why?
They don't tell you why, they just don't.
I think that you should be promoting that the legislators did not give proper attention to law enforcement authorities in enacting these reform laws.
We couldn't agree with you more.
One of the things when you were talking about pre-victimization is it's a violation of the Fourth Amendment. It appears to be unnecessary searches and seizures. In other words, having that person come back into your home after he's committed a crime and he has access to whatever rooms he was in at that time seems to me to be a violation of your right to privacy.
A homeowner. That's why I was talking about the importance of ensuring that the indigent receive money if they wish to object. But I think that's a very important issue that has to be reviewed by the appellate courts. What right, if any, does the defendant have to enter into someone else's house without due process? And also, it's got a possessory interest about the Constitution, but the defendant's coming on your house, using your house for their purposes, and unreasonable search and seizure, so you're being deprived of the use of your home without just compensation. So there's lots of potential constitutional issues there.
You've raised the alarm very clearly. It's kind of the 11th hour, unfortunately. So my question is, have all the 8 associations gotten together, compiled a clear plan to present to the state legislature for correction? Or is this a patchwork kind of exercise?
So I'll just start by saying this. On Thursday across the state, there's going to be numerous press conferences, one of them which will be in Rockland County. Right now there's 9 counties. Of those 9 counties, there's at least 30 sheriffs that are going to be combining into those areas, as well as the New York State Chiefs Association, as well as the New York State District Attorneys Association, to make a clear statement at the same time on the same day across the state.
That's raising the alarm, but I'm talking about the solution.
The only way we can get dialogue inside is by raising the alarm so they know they have to deal with this. Right now, we were ignored. The district attorneys, the sheriffs, and the chiefs were ignored. They didn't listen to us. They didn't talk to us. They just didn't. We have to find a way to open that door and create that dialogue. And this is the only way we can do it. Twofold. Across the state, like we're doing on Thursday, and you, the everyday citizen worried about public safety, calling your local representatives.
And so that's a huge change. It's a massive departure from what we've traditionally always done here in the state.
So is it, just to clarify,
Yeah.
were there situations previous to this where a judge would have the ability to actually deny bail, not what they said it at, but actually deny bail and hold someone without bail?
A robbery in the second degree, they could remand them right to the county jail without bail.
Without bail.
Right.
And so that's
A
one of these
burglary.
examples.
A burglary of a dwelling, they could remand them directly to the county jail with no bail. That's gone. They can't do anything in that case.
Okay.
In law enforcement, it's going to be 10 days. And then the district attorney, then, if you think about it, he or she only has 5 days. When you break it all down into its simplest form, before, we would give the basic information. We wouldn't give the victims information so nobody could be intimidated. They would release that, as you heard the district attorney say, later on, if they were going to go to trial. Other than that, nobody had. But then when you go to the crime about tampering with a witness and all of that, and tampering with a jury, it lends itself to that happening right up front, as opposed to we never had to turn it over because they decided to plea bargain, or it was turned over the night before, 2 days before, whatever your requirement was. But again, we're taking those same things that we had to do 100% of this for cases in the past, when in fact it was needed. We only had to do it 4% of the time. But now we have to do it in 10 days and 5 days, instead of it being 45 days or 60 days. So it gives everybody a chance to look at it all, to
I
digest.
believe that this will be one of the greatest changes in the history of the state of New York in criminal justice, and I think it's very important that the public understand what these changes are, how it will affect our criminal justice system, and affect their daily lives.
It's not only the police chiefs and the district attorney, it's the New York State sheriffs, it's our municipal leaders. The New York Conference of Mayors and Municipal Leaders came out in opposition to many portions of this legislation. They've asked for a moratorium. So it's not just law enforcement, and I really do believe that once we start spreading the information, the factual information about what these reforms entail, that there'll be much more opposition to them as well. Supervisors and mayors have put together we'll call it a tour of the towns. And so we are committed to going to each town in Rockland County as a team and sharing our thoughts about the reforms and how we see them, and making some suggestions about what we think could be done. We've already met with the residents in Orangetown. Tonight, of course, was here in the town of Ramapo. Next week we'll be in Clarkstown and Haverstraw, and we'll end our tour in the town of Stony Point in December.
Continue to lobby our state legislators, asking them to stay the effective date for at least 90 days. Also, we have to ask them to provide the necessary funding to ensure that we can implement the criminal justice reforms. We must continue our public advocacy work to ensure that the public is aware of what these changes and how it will impact their lives.